Thanks, Chair. I'm not comfortable with the Human Rights Commission's position. I think they're taking a political posture which is problematic. And I think for the same reason that we had said that government departments should not come to make presentations there, I think we should have forbade these institutions to come and make political statements here. And there's confusion as well because they're speaking about land claimants and restitution. We're not dealing with that now. There's a marked difference between the holding of piece by piece land claims and saying, no, I want this portion, it must be given back to me. Was talking about amendment of the chapter 2, which your role is to ensure compliance with by all South Africans. We're not dealing with a separate legislation, we're dealing with the constitution that says that how do we consider a process of making a democratically elected government to be custodian of all South Africa's land and redistribute it equitably to all South Africans. I think you're overstretching your mandate in terms of, even that section that you have read of the Human Rights Commission Act, you're reading it out of context deliberately because you want to make a political statement which is reactionary and problematic. I honestly think you must stay on your lane and deal with compliance with chapter 2 of the Constitution by all South Africans in terms of the Bill of Rights and all of those issues there, and then allow Parliament to change the components which we think are rights and must be dealt with differently. Of course, you're members of Parliament before, you're no longer members of Parliament now. You must accept that and then deal with what you've been mandated to deal with. Thank you very much.
Yeah, Floyd Shivambu, today you woke up on the other side of the bed. You're not seeking clarity, you're not seeking any clarities on some of these issues. You're making statements, continuous statements for the whole day. Please, let's be in line with what we are doing. If there are no clarity-seeking questions, let's leave it.
Thank you, Chairperson. I'll deal with a couple of issues and Commissioner Sibanyoni some of the others. Honorable Koronov asked about the exhaustive list matter in section 25.3. Well, clearly it is not an exhaustive list, as there is reference to including, and then it lists the particular issues that need to be taken and factors that need to be taken into account. So it's not an exhaustive list. I think the crux of what we are saying is indeed that in terms of section 25.8, it does allow a departure from the provisions of section 25.2 and 3 pertaining to the matter of compensation. It does allow for legislation to depart from that as long as it is in line with the limitations clause, section 36 of our Constitution, and that is our clear position, which is a very clear position that expropriation without compensation is indeed allowed, but it should rather be through legislation than through amending the Constitution, because of the 2 points that we make in that regard. And that is the first point is that the Constitution doesn't really allow the or lend itself to the detail required in this regard, because there can't be an unlimited expropriation without compensation. It needs to be, the detail needs to be provided, and the best way of dealing with that and providing for that detail is through legislation. And then the second point we are making is that there is the well-established principle of constitutional subsidiarity, which states that in the first instance, reliance should be placed on legislation in terms of specific rights in the Bill of Rights, and not on the rights themselves, but on legislation that gives detail, that gives, which basically gives detail about how exactly it should take place, what would be the conditions for that, and so on. And therefore, we are advising, as we have to do, we have the duty to do that in terms of section 13 of the South African Human Rights Commission Act, that it might be even flying against the principle of constitutional subsidiarity if the legislative route is not taken, but the Constitution is instead amended. In terms of the question whether we would be in a position to approach the Constitutional Court with regard to the provisions of Section 25(3) and how it should be interpreted, well, obviously we will have to still survive the test that it should be in the interest of justice to do that. And I'm not sure whether the Constitutional Court will allow us to do that in a vacuum. The Constitutional Court would most probably say, you know, the route to go is that there should be legislation that can then be tested and interpreted in terms of Section 25 of the Constitution. And I understand that government is also planning certain test cases and so on in the Constitutional Court that is based on specific facts and specific circumstances and not being done in a sort of a vacuum. And I think that that should rather be the approach. And if there is such a matter of that nature that is brought to us, we might be in a position to assist and also go to court. As far as that is concerned, we are specifically mandated in terms of our act to approach courts of law whenever that might be needed. Just the one other point that I wanted to clarify is to say that, yes, the point was made that isn't this now the only route because there is no law of general application at the moment. And I think that exactly is the problem, that maybe Parliament should first make sure that there is a law of general application that can then be interpreted and tested in terms of the Constitution if necessary, but that makes provision for expropriation without compensation. We are in favor of expropriation without compensation under certain specific circumstances, and in our longer document that we have presented to the committee, you will see exactly under which circumstances we would think expropriation without compensation would indeed be appropriate. All we are saying is that the Constitution absolutely allows this Parliament to do this by means of a law, legislation of general application, and we are recommending that that is the possibly the preferred way to go. And just in answering the Honourable Shivambu, I think it is very clear from what Commissioner Sibanyori read earlier in terms of Section 13 of the South African Human Rights Commission Act, that this is exactly, we absolutely within our mandate, we are, in terms of the Constitution and our legislation, the custodians of the Bill of Rights. This is about a right in the Bill of Rights, and we are giving our best possible advice to Parliament in that regard, as we are not only mandated, but required to do in terms of our Act.
Chairperson, thank you very much. Maybe just to start by saying thank you, Mr. Swart, for the condolences to the Sibanyoni family. And it goes to the whole family. I omitted to mention that in our presence here, I've got my daughter who's a student at UWC sitting there at the back. Can you wave your hand there? Whom I named after my father, after my mother. She's Rosalind. You are spot on, Mr. Swart, to say it is very clear. And then also to emphasize the fact that we, as the Human Rights Commission, we operate in terms of the Constitution. We also operate in terms of this enabling legislation, the the South African Human Rights Commission Act. And then because we've got a mandate, and then that mandate we need to do it, exercise it without fear, without favor, without prejudice, without bias. And then we always stay within the enabling legislation. I want to emphasize that. We are an independent institution, human rights institution. Thank you.
We extend our thanks to you, SAHC, for enriching the process and participating in this public process of the CRC. Thank you very much. And good to see you, our old friends, in you. Thank you very much.
Thank you for the opportunity, Chairperson and honorable members and members of the Constitutional Review Committee.
Thank you very much. And interestingly enough, I think both of us have been members of this committee before.
Yeah.